Good morning. On such a fabulous sunny morning here in South Florida, welcome on behalf of Miami Law, the International Arbitration Institute, and the White & Case LLM International Arbitration Program. It is a delight to be with you and to see what's happened to arbitration in Miami. It's truly extraordinary. And our arbitration week, again, I applaud everyone's efforts. It's great. And I offer my welcome on behalf of myself, my co-chair for the White & Case International Arbitration Program, Albert Jan Vandenberg, who couldn't be here but loves Miami and contributes immeasurably to our program. And of course, for a long-time partner, and now at Paul Hastings, Jonathan Hamilton, who chairs our International Arbitration Institute. And the extraordinary thing about Miami Law and our LLM program are the professors and the students. And today we're going to hear from, in fact, speaking, Louis O'Naughton, who will be our lunchtime performance from Nelson Mullins, and he's also co-chair of the MEAS Investor State Conference. Harry Burnett from King and Spalding you'll hear from, Kathleen Paisley, and we have so many stars on our faculty, world-renowned arbitrators, advocates, and others who contribute their time and effort to really teaching the future of international arbitration here at UM. And we have been rated one of the 10 top programs in the United States, and we're one of the only programs that is solely focused on international arbitration. The other thing we have are great students. They're fabulous to teach, extraordinarily motivated. And the good thing for you is, practitioners in Miami, or really around the world because they work often virtually, is we have a practicum. And they earn credit for working with international arbitration practices each semester. The good thing for you is you've got smart, motivated students to work with, and they're free. They're working for credit. I always get several of them to assist us. And today, for the first time, one of our alumnus from the LLM program, Brian Vaca at Hughes Hubbard, is speaking. So it's been about, 10 or 15 years in the program, and our students are really moving up in the profession. Many of our students are here today helping. Raise your hands, let's thank them. They're fabulous. And for all the practitioners from Miami, we invite you to our Lunch and Learn sessions here at the university. You can come talk about a cutting-edge issue and have lunch with our students. We'll organize it. Let me know if you're interested, and we'll get it set. And this year, my last announcement, on February 4, we have a fabulous White & Case annual lecture, but it's not going to be a talk at you lecture. We're going to do an assessment, a comparative assessment of arbitral versus judicial decision-making and what's best, how do they differ. And we have, of course, the quintessential arbitrator, Albert Jan Vandenberg, on a panel with judge, now arbitrator, Ursula Ungaro, who was chief judge in the Southern District, and we also have Gal Leone, who was a twice general counsel, who will be giving the user's perspective on each of these things. So it'll be lively, it'll be fascinating, and I invite you all to come. So get to know our fabulous students, help us educate the next generation, and enjoy the day. We welcome you on behalf of the university. Exciting things are going on here. We have a new dean of the law school, just full of energy and vision. And, you know, I think we're going to do some more great things. So thanks very much for being here. And now, my pleasure to introduce Don Hayden.
Welcome. My name's Don Hayden, and I'm one of the co-chairs of the event today. I do it with LISA2024. We started this event 3 years ago. The first year it was great. Last year was even better. And this year we changed it up a bit, moving it to the Sunday of a holiday weekend at 8:30 in the morning. But obviously we do it in conjunction with the ICCs in town, and we have a lot of practitioners here, so we want to have the benefit of all that. And I think you're going to find that the debates today and the discussions are going to be very timely, interesting, and I like the format. We do a little bit of debating. We do the Tinley Hall style discussions in the afternoon, and there's a lot to talk about with regard to the future of investor-state disputes in this rapidly changing global environment. So welcome to the third annual LATAM Investors, MIAS LATAM Investors State Disputes Conference here. We've got a great partnership with the University of Miami and the International Arbitration Program, not only with regard to this conference, but also many of our programs and activities could not have been done without the assistance of the University of Miami Law School and program. We also are in our second year of the Miami Arbitration Week, and this conference is just, I like to call it the cornerstone of the Miami Arbitration Week, but it is. It has become quite a week. I'll remind you, it is not a sprint, it is a marathon. We've got a long week ahead of us. Today, we have the conference. We have, yesterday, some of you may have been in Coral Gables for the LCIA event. I heard it was a very interesting event and a great location for future events. We have, obviously, ICCs in town and several days of conferences with the ICC on Latin American arbitration. We have the MIAS cocktail reception on December 3rd. On December 4th, we have the traditional FIU hangover event that has some really interesting programs with a lot of in-house counsel speaking on various arbitration issues. That should be a very interesting morning. Also on the 4th, we have ICDR is doing a program on emergency arbitration at their facilities. Chartered Institute and JAMS are working in conjunction on Frontiers in Arbitration is the title of their program. Given that FIFA decided to put its headquarters here in Coral Gables, we have a sports arbitration program, which is both timely, interesting given the World Cup coming to the Americas this next year. We have, given the rise in technology that we have here we've seen a lot of influx of technology and private equity coming into Miami. So on December 5th, there is a program on technology and arbitration. Also that evening, there is a program on art arbitration, given that we will be sharing the city with many people that will be basiling through the various art events. And then there's a program at Reed Smith on Miami as the gateway to Latin America. And then Young Mias and Friends has another event on the 6th. So, like I said, there's a lot for everyone. Both folks that are real active in arbitration or people that really want to understand what's happening and learn a little bit more about what we do. So very happy about that. And I am now I have to do some practical pointers. For those of you that have done this program, we want to have a lot of interaction. There is an app, and there is there should be materials on each table with the app barcode that you would scan in. Once you're able to scan it into your phone, you'll see that for each of the morning debates, there'll be questions. You can navigate it going from debate 1 to 2 and 3, and you can input questions for to be asked during the debate, some ideas, and then at the end we'll take a poll on whatever the question at issue is among the participants. So that'll be for the debates. Also the same thing for the Tinley Hall style afternoon. You'll be able to raise questions and put them in the queue for the moderators of that event, of that activity. And so finally, I'm really proud of how BIAS has developed, and this year, under the guidance of Silvio Marcelli, who is our chair, we added another program, a writing competition that was widely received, and we're happy to award that award for the writing competition today. So, Sylvia.
Good morning. We at MIAS are committed to cementing Miami's role as a world-class international arbitration hub. And as chair of MIAS, and as Don was anticipating, I'm proud to say that as part of our very ambitious agenda, which includes not only this content-intensive program, as you would appreciate, also the Miami Arbitration Week, tremendous, I would say colossal effort led by my partner Estefania San Juan at White & Case, Enrique Molina at Omni, and Catherine Menendez de la Cuesta, who should be here as well. Thank you very much for your efforts in leading that. But to all of that, we have this challenge, right? And every year as a new MIAS chair takes office, we have a new ambitious goal under Richard Lorenzo's leadership, who's here in the room. We did my Miami Arbitration Week last year, and we kept growing on that tremendous progress. We did this conference a few years ago under Luis and then Don's leadership. So I had to come up with an idea, and I thought that in line with our, again, agenda of showing that Miami not only has the looks, but also has the brains, we thought that we would launch this writing competition. A writing competition that we are glad to announce, Ms. Gaurika Mohan has won, and please come here. Gaurika is a rising star. Thank you. Now you have to stand here and, listen to me talk about yourself. It can be awkward, but you just keep smiling and it will go fast. Gaurika has earned her LLM degree from NYU, where she was also very actively involved as a student in the International Arbitration Society. She has gained extensive experience while working at Linklaters, among other leading firms, and also at Shell, right, as a second D of the legal department there in India, and show a testament, I think, to that bright path ahead of her. She will be joining Professor Gary Bourne's team at WilmerHale in London shortly next year. Her article was very insightful and was entitled Derogation from Mandatory Institutional Rules and Analysis of the Challenges and Consequences, was selected the winner. The process of selection was chaired by our dear colleague and friend of Mia's, Professor Manuel Gomez, and also included Ava Borazo, Al Lindsay, and Richard Lorenzo. And they concluded that, I quote, Garrica's article demonstrated exceptional originality, comprehensiveness, clarity, and rigor, setting it apart from the many other submissions. So per the competition rules, you will be awarded a cash prize. I will not give you the check right now, but it's there, I promise. And this plaque commemorating
Thank you.
the winning. Thank you so much. And if you want to read the article, it will be published in the next volume of the World Arbitration and Mediation Review, edited by FIU, again, under the leadership of Manuel. Manuel, thank you so much also for all your efforts on this. Thank you.
Good morning, everyone, and congrats on that very good article. It's a great testament to what MIAS is doing globally, the fact that we have such a great competition and can honor really future talent like we're seeing today. And to get us started, I first want to apologize for my voice. Obviously, my voice is a little sore. I didn't realize that MIAS was going to be starting on this holiday weekend, and it's still on holiday, but hopefully you can hear me. And you've had your coffee and breakfast and are ready to engage in a very lively discussion about third-party funding, a very important issue for investment arbitration. Third-party funding has had a significant impact on investment arbitration, particularly on investment arbitration in Latin America. We see it now with the enforcement of new disclosure rules that a lot of the investment arbitrations that are being filed are in fact funded. And in fact, the empirical data confirms that claimants are considering funding as an option even when they have the resources. Just by a show of hands, how many of you have had the investment arbitration in which a third-party funder was involved in the last 2 to 3 years? As you can see it, the response is overwhelming. Investment arbitration is being impacted by third-party funding. Now, there are two views to this reaction, to this factor, to this consequence. The first one is that third-party funding is opening the doors of justice, is the access to justice debate, the access to justice argument. On the other hand, there's the issue about how third-party funding is allowing claimants to file claims that are either frivolous, some people claim, or claims that would not have seen the light of day without third-party funding. And between those two extreme positions, there's really a debate taking place by stakeholders that are really involved on the ground and from different perspectives as to how to deal with the different challenges, with the different disclosures, with the different positions that are taken by the parties with respect to funding, and how do we ensure transparency in the process. And to guide us in that debate, really we have an excellent panel of people that are really on the ground dealing with these very important issues. To my left, I have Nick Sage, who is going to talk about his experience and his perspective from as one of the leaders in bench walk, and how he has seen funding grow and how he has processed funding of third-party arbitration and arbitration claims from his perspective. We also have Juliana Giorgi, who is with Qanlex, and is going to talk about her perspective as well. And of course, we have Jeffery Commission, who's joining us today from Burford Capital, and is going to share his experience on these very important issues. And Jeffery, I want to start with you. There's a lot of information out there about third-party funding and the impact that third-party funding is having on investment arbitration. As I said, some people see it as a positive impact, as an impact that guarantees access to justice. Others criticize and claim that third-party funding has really altered the balance that a claimant undertakes before making a decision as to whether pursue a claim or not. And I'd like to give you an opportunity to set the record straight from your perspective, from what you're seeing on the ground, and really respond to some of the criticism that you have heard out there.
Thanks again for the kind invitation. I think, I've been dealing with what I would characterize or call misinformation about third-party funding for some time. We see a lot of it in the context of what's going on in Untitled Working Group 3. And, it comes in various forms, but most oftentimes it's misdescriptions of what's going on in investor-state arbitration. And, to my mind, there are three main critiques or criticisms that have been raised. And if you look at the underlying empirical data, the actual outcomes of the cases, by looking at the cases and calculating wins and losses, many of these critiques are just misguided. So number one, and these are probably the main ones that are advanced in Working Group 3, and that have been, we've seen it in some arbitral decisions. The first is that third-party funding is somehow increasing the number of frivolous or what some NGOs call marginal claims. Now, this one we've debunked, I think, in an ILFA submission to Untitled Working Group 3, but there are mechanisms in treaties. There are mechanisms in investor-state arbitration rules, like in ICSID, that provide for summary dismissal. We've looked at outcomes, and there has not been there's not really been any increase in the number of cases that have been dismissed for manifest lack of legal merit, for instance, under the ICSID rules. So presumably, if third-party funding, which has been going on for more than a decade, is increasing the number of frivolous cases, you would see more of them being dismissed on summary dismissal, either through a treaty provision or the ICSID rules. We haven't seen that. Secondly, there are certain groups that are saying that funders are negatively impacting, their involvement is negatively impacting the disposition of cases. And here it's not just NGOs. There's one arbitrator who earlier this year rendered a declaration on costs in a controversial ICSID arbitration that was both unnecessary and highly politically motivated. In this declaration, he went on to rail against third-party funding. And this goes to the data. If you look at some of the things that he said about third-party funding, he says, such funders may be closely engaged in the conduct of proceedings which can be burdensome, time-consuming, and sensitive. Footnote 12. So then you go to footnote 12 and you expect to see something that supports this proposition. But you don't. You see a reference to the ICA Queen Mary Task Force, which nowhere says that. And there are several other references in this particular declaration that when you go to the data, you go to the footnotes, the supposed authority, and that just don't line up. And the same thing goes for many of the submissions in Untitled Working Group 3. When you look at the data, investors are not winning more than claimants. If you look at outcomes in 2023, based on the most recent UNCTAD paper that came out last week, states are winning actually more than investors, if you include or factor in discontinued cases. Finally, the third critique that's often made is that somehow, because of the increased use of funding, that the amount of damages that are being claimed has increased. Now, it's true, based on the empirical data, that there has been an increase in the damages claimed. But it's not due to the fact that third-party funders are involved. Quite frankly, third-party funders are not damages experts. We are not subject to cross-examination. We are not writing the independent expert reports that tribunals look at. If you look at the actual cases, the rather large cases, what you see are states are becoming quite aggressive, particularly in the extractive industries, in taking over very valuable mineral properties. And you see that both in gold, in copper, in silver, in lithium, across the spectrum. So, it's not surprising that many of these, and particularly in the mining sector, which constitute 28% of ICSID cases at present, these are large claims and large damages, because these are large deposits. Oftentimes in the mining context, cases where the foreign investor has gotten to the feasibility stage. So they're just about to hit production, and then the state takes it over. Anyway, I'll pause there. Those are the three main critiques I've seen.
No, thanks, Jeff. Nick, how about the criticism that third-party funding alters the balance that a reasonable investor goes through before making the decision to pursue a claim or not? And the idea is that even if the claim is not frivolous, a reasonable investor is more inclined to pursue a claim if it has third-party funding as opposed to having to use its own resources from that perspective.
Look,
I think it's certainly possible that a party who obtains funding may be more likely to pursue a claim than they would in the absence of funding. But I think if we take one step back from there, if you look at the number of ICSID claims that have been filed over the past 12 years or so, the numbers are relatively constant. They vary between 10 or 15 each year. So if you're going to think about the idea that funders are increasing the number of frivolous claims that get filed, you have to see an increase in the number of claims that get filed. That has to be sort of the first building block of this concept, because if the number of cases getting filed is relatively constant, that must mean that more frivolous claims are getting filed and fewer meritorious claims are getting filed. And that, the data just doesn't bear that out. So I think that the starting point of the data just shows this is not really a true thing. Whether a plaintiff or a claimant is more likely to pursue a claim with funding in place, that may be correct. But if a funder is providing funding for a claim, particularly in this context where the funding arrangements are always large investments on a single case basis, the funder is going to believe that the claim is meritorious. I was thinking about this morning. The idea that a funder would knowingly fund a frivolous claim is just antithetical to what a funder does. And I can't think of any other industry where the critique is, you guys are doing something so that you knowingly lose money. I think that it's a tough argument to handle, because it's so antithetical to what we do that it's kind of hard to know how to respond to it. And if that is what funders were doing, we'd be going out of business doing it, without a doubt. We could go out of business very easily, funding lots of opportunities that we see that we pass on. Funders like to talk about the number of cases that they pursue as a ratio of those that they don't. And I think most funders are somewhere in the neighborhood of 3 or 4 or 5% of cases that we actually fund as compared to what comes in. So it may be that a party who obtains funding is more likely to pursue their claim with funding in place than not. But I would take that as a sign that there is a consensus among that party's counsel and the funder that they should do that. And I'm not sure why we would think that is a negative in any way. To the contrary, if we believe that parties should have access to justice and be well represented by legal counsel, particularly in this field where you really need very experienced and sophisticated counsel to do this properly, then these are exactly the parties that should be pursuing their claims.
How about you, Juliana? Do you have any appetite to fund frivolous cases?
No, not at all. Not at all. And actually, our guideline principle as funders and as a fund is to our fiduciary duty to the investors. So we have to protect in any way the investments, and in that sense to do or conduct comprehensive due diligence to ensure that we are going to invest in a good case, in a case with legal merits. So I think that's our main principle. And one thing I would like to share with you is our experience investing in Latin America. We have not encountered, the experience has been totally positive. We have not encountered in the region this kind of criticisms, because third-party funding here is a novelty. We're here in Latin America. It's a novelty. So in my work, I have to hold meetings with a lot of attorneys and CEOs from all over the region, from Mexico to Argentina. And we have found that there is no bias. There is no misunderstandings to correct, because third-party funding is embraced as a novelty. So that's one point to highlight. And second, we are benefit. The region is it's improving by implementing the solutions that are being put in place in other countries, mainly common law countries, to counter this kind of criticism. For example, following the amendments to the ICSID and ICC rules to include the duty to disclose this kind of funding arrangements, some arbitration centers in the region, for example, Quito and Mexico arbitration centers, have included the same duty as well to disclose the funding arrangements to promote transparency in the cases.
Now, talking about the process itself, in terms of the underwriting process, an investor has a claim, attorneys come to you, Nick, with a potential claim, and it's an investment arbitration. How is the underwriting process for an investment arbitration different than the underwriting process, say, for a litigation in federal court or a commercial arbitration?
So in looking at a treaty arbitration, the first question I ask is, who is the sovereign? And we may continue the conversation after that, or we may not. I don't ask that question first in a standard U.S. litigation where I need to hear more about what happened before I get to that question. I think there are a lot of things motivating that. The first is that the cases that we see that are candidates in this practice area are quite often strong on the merits, far stronger on a more frequent basis than I see in your standard U.S. litigation. The difference is that there are a lot of other things going on that may make funding challenging. So one of the things that always comes up is, how expensive is this going to be to fund? These are always expensive cases to fund, and there's no problem with that. But the related question is, what are your damages? The damages just have to be large enough to support the investment. And we've got to the point where we generally require seeing tens of millions of dollars of sunk costs in a treaty arbitration before we're willing to consider funding the case. And many cases don't fit that criterion, unfortunately, for the claimant. But that is what we've taken the position that we need to do to sufficiently protect our investment, in part because of how expensive it will be, but also in part because of how long it will be. And that's a related issue. These cases take a long time to resolve, generally longer than any other kind of case that we fund. And that's fine, but that means that you have to have enough room for the damages to support the investment that you're making. Then we come back to the sovereign and how easy or challenging will it be to get money out of them. And what I like to say is the worst thing that a funder can do is win a case and have nothing to show for it. I'd rather lose a case, frankly, because what have we done? We've put ourselves in a position where we've done everything we set out to do, yet have nothing to show for it. And it's very hard to explain to your investors how you spent their money and got them to that place. It shows that you can, suss out a good case, but don't know how to sort of bring it home. And that's not a great look for a funder. And then the last thing is political risk. These cases, they're political, unlike most other cases that we look like. And that is kind of hard to underwrite. There's not necessarily a science to it, but it does militate in favor of being particularly careful with these cases because you have a variable at play that is just not at play in most of the other opportunities that we see. And you just have to make sure that you're investing in a claim that really looks very solid across all other levels, because that's something that you really can't control for too large part. And it's a risk that you're knowingly going to take on when you fund any treaty case.
Now, let me drill down on the point that you made, the point about damages. We have a number of arbitration practitioners in the audience. How can they help you reach a comfort level where you're comfortable with a number of damages involved in a case so that you can proceed and fund an investment arbitration?
Well, I will say that practitioners in this space do a better job at that than practitioners in other practice areas who sometimes end their conversation with me saying, I think the damages are $200 million to $1 billion, but I don't know anything more than that, which is fine. They're both high numbers, but it doesn't give me a lot of comfort that anybody's actually studied the issue. We focus a lot on sunk costs, and oftentimes an expert will be involved in calculating what those actual numbers are. And we really do need to see some version of a preliminary expert report showing us how you're getting to that number and what interest may be expected to grow on top of that number. But without that, it's very challenging, and that can be a lot of work. It can be expensive work. It can be time consuming. But without the comfort that the damages are going to be what we need them to be, we aren't able to proceed. But I just want to reiterate, I do think the lawyers who know what they're doing in this space do a very good job doing that and position their clients for success when they're able to.
Jeffrey, how about you, from your perspective? What's been your experience with underwriting investment arbitration, and what are the unique issues that you see in investment arbitration that are not necessarily present in other type of cases that are funded by your company?
I mean, we fund a wide range of disputes. Arbitration is really just in any given year, 15 to 18% of our portfolio. And, it is significant. The current portfolio value is about $7.2 billion, so it's a good chunk of that. But these cases, I think the point about duration is well taken. These cases take, when you have to sit down to prepare a model with your analyst for presentation to your investment committee, you have to model out when you anticipate payment. So you have to look at the sovereign in question. You have to look at who they have historically retained as counsel. You have to look at the win-loss rate that counsel has. You look at the office. You look at the win-loss rate of particular lawyers. Some states don't, and it's unfortunate for them, but some states don't outsource that, and it can have disastrous results. There were a series of mining awards rendered last year involving a particular sovereign where I think they were quite underserved by the in-house team, which is unfortunate. I think with some guidance and some sort of outside counsel, and it's not. It was a rather clear-cut case, and there were concessions that the in-house team made that were unnecessary and unfortunate. So I think you also have to look at the track record of the arbitrator. In some cases, we know the panel. In other cases, it's something that we don't yet know. But that's really important in these cases. If you get a tribunal chair that has never awarded damages in excess of $100 million or in excess of $1 billion, it's going to be very difficult for you. Quite frankly. So the tribunal composition is very important, I would say. And increasingly, when we're looking at, because obviously we underwrite claims and we look at all of the things that were mentioned, I think they're all very salient. But in monetizing or purchasing awards, we also have to look at the set-aside risk. So you may win, but then the number of cases that are funded that are subject to set-aside applications has increased significantly. So you almost have to build in another 18 months to 24 months for that extra period, build it into the budget, as well as building in enforcement. And the rates, although they haven't changed, like ICSID, it's still a single-digit percentage on annulment, as Sylvia can attest to. But if you look at non-ICSID cases, the rates are significantly higher in certain jurisdictions. A recent study showed it in double digits, for instance, in Paris. So you have a number of national courts dealing with set-aside applications involving investor state awards, and the outcomes have become increasingly uncertain.
And let me drill down on this point of the arbitrators. How important is the composition of the tribunal in terms? You mentioned track record. How about writings out there that the arbitrators have published? And do you have a preference in terms of funding a case prior to the composition of the tribunal or after the tribunal has been fully selected, including the appointment of the president?
Well, of course, I have a preference to only fund a case where I know the tribunal, but invariably it's very rare for that to happen. Usually, the better cases are subject to a competitive bidding process. So obviously, you're competing against other funders both on terms and other things. But I think it would be much better to know the tribunal. But if you don't, I boil it down to track record, but obviously we also look at the writings. We look at other arbitrators that person has sat with. We look at the number or frequency of times that arbitrator has dissented. Because if an arbitrator is dissenting all the time, what they're not doing is convincing the chair of a better outcome, so to speak. So it's not just wins and losses, it's how those cases went. We also look at firms that appointed that arbitrator in prior cases. We look at that arbitrator's path to becoming an arbitrator. Were they... Did they work at a firm, and what kinds of cases did they work on when they were at that firm? So we look at all of that and try and come to a view. It's not perfect, but it's increasingly focused on the data, much of which in the investor state context is available.
And in terms of duration of the proceedings, how you project that, do you include the possibility of an annulment, or you just focus on the actual arbitration of an annulment proceeding, that is?
In cases of certain respondents, you have to assume. Anyone funding a case against Spain or buying an award against Spain in the PV sector has to assume, because every case has been, they've sought an award in every case. And the same for a while was true for Venezuela. The same, you look at the track record of certain states and they always file for annulment. Now, it doesn't mean that proceeding results in a decision on annulment. Some cases they're discontinued, they're just buying time. But you do have to increasingly, with some sovereigns, you have to factor it in. Other sovereigns will file for set-aside and then sometimes settle midway through, or settle as soon as it's decided. But increasingly, we need to include that in our budget. if we think that that sovereign, and many of them do, is likely to seek challenge any award at the seat.
How about you, Juliana, your perspective in terms of the underwriting process and how is different than other disputes that your company funds?
Okay, well, regarding the resources we allocate and the processes we follow in Qanlex, there is little difference between commercial or investment arbitration. Of course, it is true that investment arbitration is more complex. The costs are higher and also the time. So yes, we have to go beyond analyzing the legal merits of the case and also analyze another kind of things like the political stability of the state, the willing to pay of the state, and also an eventual enforcement of the award. As Jeffery mentioned, in Qanlex, we analyze a worst case scenario to take into account all the steps that we will have to follow to enforce the award. For example, the annulment, the collection proceedings, if that's the case, and also to bear in mind all the costs that we will have to face if we have to face this worst case scenario.
In terms of political stability and the political situation of the states in question, Juliana, can you speak to us as to how important that is and how, from your perspective, that risk is analyzed and addressed in your underwriting process?
Yes, well, this has a lot of connection with the last questions. And in Latin America, we have an ever-shifting political landscape. Historically, we are countries prone to political changes and also to fluctuating policies. This political volatility is characterized often for changes in government's ideology that comes with ideas of nationalization, also by changes in regulations. Recently, we have seen this in sectors like energy, oil, and mining, especially. And this, of course, causes a weakening in the rule of law. The impact in third-party funding, is mainly twofold. The first impact, which is, I think it's positive, is the rise in the number of claims. So, of course, third-party funding will be sought because of the high cost of investment arbitration. And the second consequence that is negative, if an investor is successful in an arbitration, and also the ruling in the award is contrary to the interest or policies of the state, well, the state may fail to honor the award and will resist its enforcement. This scenario is highly problematic to funders, of course, because it involves additional cost and additional time to seek the enforcement. So we have to recourse to tools to trying to find out if a state will be willing to pay an award. Unfortunately, there is not much information available regarding the compliance of awards. So one important that we have seen and we are looking is the paper on the compliance and enforcement of exit awards that was recently, 3 years ago, published by the Exit Secretariat. And just to highlight some numbers, as to the 151 damages awards considered, the research showed that award debtors voluntarily complied with or reached a post-award settlement in 66% of the damages awards. Award creditors did not pursue enforcement in respect of less than 3% of damages awards at the time of the study. Enforcement was pursued in relation to 31% of damages award, which I believe is a high rate. At the time of the study, the outcome of enforcement actions was available in relation to 23% of the actions. Of these enforcement actions, 73% were successful and 27% were unsuccessful. That's important data to our analysis. And one second tool is that as funders, we build kind of a list of non-cooperative states, and we are updating it all the time. So in that way, we identify the countries in which we won't invest because of these high political risks, because of these changes in regime. And I can mention that currently, Venezuela, Bolivia, and Nicaragua are part of the list, followed by Honduras and Ecuador, which, they are relatively cooperative depending on the ruling of the awards. And unfortunately, Colombia, it's like fighting to be in that list as well, because the government recently announced its intention to withdraw from the exit.
You're mentioning most of Latin American countries right there.
I know, it's difficult. So yeah, Colombia it's about to enter in that list, unfortunately.
Dick, how about you? Do you have a blacklist on your pocket that you want to share with us? In all seriousness, how important when you're funding a case is the political stability and the track record of the country that is being sued?
Yeah, it's very important. I think, we as a litigation funding company, we have expertise in several things, but we're not, our investors don't entrust us with their money to analyze political risk. It's not a risk they're looking to take on. It's not a risk that we are best positioned to assess, but also to predict into the future. So from our perspective, a country whose political risk is problematic is just a country against whom we won't fund a case. It's sort of as simple as that. The data is where things get interesting, because there are a lot of data points out there for different countries. Some have settled at certain points and some have paid awards at certain points. And then you start to try to piece together, okay, well, this country has paid in the past. If I didn't know that, maybe I would be hesitant to fund a case against them. With that data, does that give me enough comfort? And sort of goes both ways, because on the one hand, all right, so maybe they have a track record that is more promising than you would have thought, but maybe that means now they don't want to pay any more awards because they're tired of doing it. So it's hard to know what to make with these sort of specific data points that aren't necessarily reflective of what may occur in the future. And I think, speaking for Benchwalk, we're just very cautious when it comes to that kind of risk. There are enough other risks out there that may pop their heads up, but which we are prepared to underwrite and knowingly take on. That's a risk that we generally stay away from, because when you couple it with durational risk and merits risk and everything else, it ends up making for a riskier investment than you need to make when you're not only looking at investor arbitrations as compared to each other, but as compared to every other opportunity that comes to a litigation funder. And when you start piling on the risks, it just they can quickly appear to be riskier than another promising opportunity.
Jeffrey, how about your perspective on country risk, and how do you deal with the country risk of the specific respondent?
I think it's one factor among many. I don't think that it is more important than other factors. We haven't spoken about it yet, but there are some good examples in the exit context of funded claimants who received an award, then monetized the award, and then got insurance for, in the event the award is eventually null. If there is a particular sovereign where there's a risk of, whether it's owing to instability on the political front or the fact that they're facing, a cascade of cases, or when you're looking at the GDP ratio, it doesn't look particularly attractive. You can get default award insurance. Now, naturally, that's only a fraction of the claim, and we know that claimants typically, on average, only get 38% of what they're seeking. But you could cover probably your investment back, the amount you invested plus a multiple on that investment through an insurance product. And the premiums they vary. Usually there's an upfront premium, there's a premium that comes out of the final award, but that's certainly an option. And, I think, there are some countries where, even that product is not available. But I think it's one factor among many. And I mean, so some of the most, if you're talking about the award monetization market right now, some of the most attractive awards and the awards that are trading most frequently are awards against a state where people would say that it's one of the most unstable, and that is Venezuela. But because you have a looming or potential auction that may occur, well, probably next year now, but you have 20 or so claimants who are in that award queue, and those awards are changing hands. There are bid proposals being put together, and these are all because one of those claimants, a savvy claimant, was able to proceed with an alternative theory for collection, and now they have the prospect of seizing something that should satisfy a significant number of outstanding award holders.
Now, let's talk about one of the interesting areas in terms of third-party funding and the regulation of third-party funding. Obviously, there are a number of rules now requiring disclosure of third-party funders, disclosure of the identity of the funders, and in some cases, we are even seeing attempts to obtain disclosure and production of the actual funding agreement. Jeffrey, I want to stay with you. What do you think about those rules, and how are they enough to regulate the industry? Are they serving an actual purpose in terms of bringing more transparency to the process? Do you feel that those are regulations that the funders can live with?
I mean, just about every arbitral institution, including commercial institutions that now administer investor state cases like the ICC, for instance, they all have in recent years adopted disclosure requirements, and they're pretty standard. Quite frankly, funders don't oppose these kinds of disclosures because they avoid potential conflicts of interest, and no funder wants an award that could be subject on set aside to a potential conflict of interest. So those kinds, and we participated both on our own and through ILFA in the ICSID revision process, which took 5 years and resulted in, I think, a very carefully calibrated rule. Now, we've also participated in the Antitrust Working Group 3 process, which doesn't appear to, whether or not it results in any rules or a menu from which states can choose. They've taken a different path that began with a proposal to ban funding entirely. That was not well received. They now are settling on something that will give optionality to states, that will provide for something like the ICSID rule plus something else. What that plus is remains to be seen. But if you look at what many of the states have said in Antitrust Working Group 3, they've extolled the benefits of third-party funding and relevant and useful disclosure to avoid conflicts of interest. That's what ICSID has said, and that's, I think, the right path to proceed, and that's what institutions have done. So we remain in favor of that. And if you look at the cases that have been administered since the new ICSID rule and other rules have come into effect, all funders are complying with these rules, and there's not been any issue.
Nick, I want to stay on this topic of disclosure, and I want to go to a question from the audience and remind the audience that you can ask your questions using the application that Don explained at the beginning. I have a question. He says, should a case involving a third-party funder require an additional disclosure by arbitrators in relation to the funder? In other words, not only is there an additional disclosure by the arbitrators themselves in connection with the funders. How do you feel about that?
So this is something we talk a bit about in the funding world and internally at Benchwalk. I'm going to speak for myself on disclosure because I don't want anybody recording this and 2 years later using it against Benchwalk in some litigation. So this is just my view. From my perspective, disclosure is fine. If the arbitrators are going to feel more comfortable disclosing the interests that they hold in litigation funding companies, go ahead. If that's what the question is getting at. I think there are probably very few arbitrators out there who own such an interest in a litigation funding company that the case that they're presiding over would have a material impact on their financial well-being. But I suppose it's possible. So sure, why not? I think the only issue I ever have with disclosure is when there are provisions in the funding agreements that identify when a claimant or a plaintiff will pay more for the funder's capital at a certain moment in time. That can undermine the integrity of the process, where you then have the respondent saying, settle the case now, because next month your capital gets more expensive. That's not how disclosure should be used. That's gamesmanship, and it's inappropriate. But if people feel that it's important to disclose these potential conflicts, then I think everybody should be forthright with each other and eliminate that issue. This comes up with litigations as well. And my view is that if you don't know that you have a conflict, then you don't have a conflict. But if it's better to get everything on the table, then let's just do that. And funders are better off not trying to hide anything.
Juliana, do you see any issue with the disclosure requirements, particularly in some instances in which the actual disclosure of the funding agreement is requested? What are the potential issues that you see from that perspective?
Okay, sorry. Yeah, as my colleagues just said, we don't oppose as well the disclosure. We think that it promotes transparency and also avoid conflicts of interest with the arbitrators. Yeah, and as Nick said, there are some special clauses or provision in the funding agreement, but they are not that common. Usually in the fund, we use standard litigation funding agreements that, according to that provisions, I believe there will be not a problem, there will be not an issue if a tribunal decides to request the disclosure of that kind of litigation funding agreement.
I want to turn to the questions from the audience. We're getting quite a lot of questions, which is very interesting and speaks volume about the interest in this topic. And one of the questions that I just received talks about settlement, Jeffrey. At the beginning, you were talking about the impact of funding on the investment arbitration process and the criticism. Is there a notion with respect to the impact on settlement? When a claimant is funded, does that have an impact on the outcome or potential negotiation or a prompt settlement of the investment arbitration? What's been your experience?
I mean, this is one of the topics to which I alluded before, about which there's a lot of misinformation. We do not control settlement. One of the critiques specifically made by an NGO was that funders want to see an award through to want to see a case through to the end to an award. That's just not correct. If we can realize a profit, if we can instead of modeling out 10 years for collection, if you can settle it in year 3 or year 2, then quite frankly that makes for a good IRR, because you would not have the amount of capital you would have deployed would be less, and you would be seeing proceeds coming in. The fact of the matter is that most of these investor state cases, unlike commercial cases, for instance, in U.S. courts, they do not settle, or they only settle after award. And then, it's oftentimes during that post-award proceeding. But oftentimes for funders, settlements are a favorable development. We don't control them. We'd like to see more of them, quite frankly, in investor state cases. And it doesn't have to be a monetary settlement. Our agreements, I think most funders' agreements, have clauses that in the event there is a non-monetary settlement, there are rights or determinations as to, for instance, if it's a particular concession, that the funder would have an interest over time in seeing proceeds or revenue from that concession. So I think a funder does not stand in the way of settlement.
Nick, staying on the issue of the role of funders in the actual process, one of the questions I have is what role do funders play in the selection of counsel, arbitrators, and experts? Can you clarify for the audience how involved are you as a funder in the selection of counsel, arbitrators, and experts, and all these different decision-making process and opportunities throughout the litigation, the arbitration?
Yes, so that varies on a case-by-case basis and also on a funder-by-funder basis. More often than not, the parties who we are working with are already represented. We are very careful not to interfere with their attorney-client relationships. In terms of the arbitrators or experts who may get used, that's a different question. When people come to us looking for advice, we're always happy to provide it. I think in general, we like working with lawyers who are already very well equipped to make those kinds of decisions on their own. We have no authority to make those decisions on their behalf, but whenever somebody wants our input based on our experience, we're happy to provide it, and that can make for a very good working relationship. On the other hand, there are a lot of lawyers who think they're very smart and they're right, and they often advise their clients very well on these issues, and we're happy to follow their lead as well.
Thank you. Juliana, the last question I got here has to do with the risk assumed by the law firms. How much do you expect law firms to participate in the risk and assume the risk of the funding or a positive outcome in the arbitration?
Okay. Well, we don't expect the law firm to assume risk. We maintain all the time like an independent relation with of course, with the law firm, but we don't interfere with that kind of arrangements. I mean, we have the principle to maintain a passive role. So the fees agreement with the client, we don't intervene in that. We don't have an opinion on that. So, but I've seen cases in which the client and his or her attorney try to agree on fees, on contingency fees, just to get to an investment ticket and to have the funding of the case. I have seen that, but the most important thing is that the fund always have a passive role on this kind of arrangements.
Jeffrey, how about from your perspective? Do you require law firms or do you expect law firms to participate in the risk through a success fee or some portion of their fee on a contingency basis?
I would say we don't require it, but it's quite common. It certainly makes a particular opportunity more attractive. Obviously, if you're looking at a single case, it does. Obviously, we do a fair bit of portfolios with firms. And in those cases, there are agreed parameters for the kind of contingency consultation about that. But yeah, I think it shows that the firm is likewise incentivized and interested in the case.
Okay. We're running out of time, but I want to give you each an opportunity to give advice to the arbitrators and the practitioners that are in the audience as to how they can improve the prospects of getting their investment arbitrations funded. If there's one thing that you would tell an attorney in the audience, Nick, as to how to make the process better and more likely to result in a positive funding outcome, what would that be?
Yeah, so in this space in particular, I often come across strong case with an enforcement strategy that is less of a strategy and more of an idea or a hope or something. This is why I think this country is going to want to pay this award. And I don't know if the country is going to want to pay the award or not, but I want to know if they don't want to pay the award, what's your plan in that event? And that's where I sometimes find the submissions lacking. And that's what I would advise. Come up with the best strategy you can, because that is often the reason why we may decline to fund the case.
Juliana?
Yes, that's important. And I would like just to add that it is important to ask when the law firm help us to see all the phases of a case, all the risks, the arguments of the client, but also the arguments of the counterparty. And it allows us to do or to conduct a comprehensive due diligence of the case. And it's also efficient in terms of time and to get the funding amount the client needs.
Jeffrey?
I would say start backwards. Don't start with jurisdiction. Start with how you're going to get paid, how our award proceeds is going to be collected, and then get into the merits. If you're presenting us with a case, we assume it has a cognizable claim or under the treat or what have you. But I would say, start at the end, and then number two, oftentimes claimants, particularly on single case funding opportunities, are better served if they have an initial assessment of quantum, either because they're savvy and they've done a lot of these cases and they can put it together themselves and they draw upon prior precedents, or they engage experts and they get preliminary opinions. A lot of these experts will do these opinions just for the opportunity to be included in a beauty period later on to be selected. So I just think, start from the backwards and, leverage the relationships you have to get, to showcase the case in the best possible way, particularly on issues of quantum.
No, thank you for that insightful information. Please join me in thanking Nick, Juliana, and Jeffrey for sharing their experience and helping us understand the funding underwriting process. Thank you.